What's up, everybody? Welcome back into another episode of The Lawyer You Know. And today we're going to talk about the Brian Walshe case first. Why is it continuing to get delayed? It was supposed to be in trial this week, then it was supposed to be next month, and now it might be delayed again. We're going to talk about why, how that process works, what's the difference between competency and insanity, answer all your questions around that. Then we'll switch gears and talk about Kouri Richins, some updated filings in her case that, from my eye, look like some major admissions of weakness for the prosecutor that, depending on how the judge looks at them, could absolutely affect bail and other things to come in her trial that are going to be some major points the defense is going to be able to highlight in front of that jury. And then I think we'll have some time at the end for some AMA, Ask Me Anything Q&A type of deal. It was fun a week or two ago when we did that. So we'll try to do a little bit of that today as well. Make sure you guys hit that like button. Thanks for coming to hang out with me on Friday. Let's get to it. So the first case we're touching on here is Brian Walshe, and we know about that case. We've already kind of done a factual basis and background of the case and everything that's going on there. But what is currently happening is Brian Walshe and his team are working their way towards trial while simultaneously trying to get exculpatory information, whether that's from Proctor's texts, Proctor's phone, or from the FBI materials that were turned over in Karen Reed's case. And they were also trying to get certain evidence suppressed. They did get some evidence suppressed, not most of the majorly damning evidence that, is allegedly available against him. It doesn't seem like any of the Proctor texts are going to be something that's available to Brian Walshe, which, if he's guilty and he did it, is a good thing. If Proctor did talk about him, obviously that should be important and should be included in his trial. As we're kind of dealing with what's happening in that case, that fight still continues to be happening. But it's interesting because when we have a competency issue, when a client is deemed to be incompetent, everything in their case halts. It is stayed, it is stopped. The lawyers can't work on the case. And the reason for that is you as a defendant have a right to be involved in your defense. And if you're not competent, you don't have the ability to do that. You don't have the ability to understand the legal implications of your actions. And if you don't understand the legal implications of your actions, then you obviously can't participate in any of the legal proceedings, which is, in fact, your right. And therein lies the distinction between competency and insanity, right? Because competency has to do with, can you stand trial? Can you help your attorneys? Can you say, oh, the witness said I was there. That's impossible. I can prove I wasn't there. Can you say, maybe we should go with this defense? Should I testify? Should I not testify? How are you supposed to talk about something like that if you're not competent? Insanity, on the other hand, is at the time of the offense charged. In Florida, do you have, some kind of mental infirmity or disease or defect? In other states, you don't necessarily have to have that. But generally, do you know right from wrong? Do you know what you were doing is wrong and what the consequences of what you were doing is wrong and what those consequences actually were? And if you don't, then in some states, you can get a lesser charge. In some states, you can be not guilty by reason of insanity. It really depends on the rules in your jurisdiction. But insanity is at the time really not knowing right from wrong and the consequences of your actions at the time of the crime. Competency is at the time of your trial or the litigation against you. Do you understand what's going on? Can you help and strategize in your defense? So those are the two big ones. And from my perspective, it seems like a lot is still going on in Walshe's case and Walshe's defense because they're still trying to get a lot of documents. It seems like they're still filing motions. They're still having hearings. A lot of it is sealed, so it's hard to really get all the documents in those cases. If you guys ever come across something that you have a question on, as always, feel free to send it to me. I am wondering who questioned Walshe's competency and why now for the timing. Why do you guys think the timing is happening right now? Put it in the chat. Maybe you guys already know because there's a lot of details going on in this case, but I have had a lot of questions about why the timing, right? Why right before this trial? And from my perspective, I think everything should probably be halted in this case and they should stop working on it. I know they don't want to. I would never want to before trial either. But if the defense has a reason to believe that Brian Walshe is not competent, they really shouldn't be pushing forward and making major decisions and filing motions and handling a case that way if they don't think he's competent. So I'm interested to see exactly how the judge handles that. Benny Bella said, love your hoodie. Yeah, I love this one. I don't even know if this is mine or somebody left it here at my house, but I do. I love this one. I have a couple of them. So this is probably my favorite hoodie we've ever had, if I had to guess. But so what's happening in Walshe and why this timing? So they brought up the fact that there might be a question with his competency. Okay. And once you do that as a defense attorney, the judge is basically, their hands are tied and they have to say, okay, well, let's get some kind of an evaluation. And if we have an evaluation that says he's competent, then we're good to go. If we have an evaluation that says he's not competent, obviously we can't go. And this is an issue that has been overturned multiple times on appeal. If there's a competency issue with the defendant and the judge or somebody just pushes through until trial. Somebody said you must have the air cranked up. It's definitely not cold enough here yet for a hoodie. It was like 60 degrees this morning when I was playing pickleball. It was amazing. It's beautiful weather. And from my perspective, that's sweater weather in Florida. And I'm going to a high school football game tonight. Like, is there anything better than that? So the judge's hands are basically tied. He is sent off for an evaluation to a state hospital, and the evaluation is continuing. I think usually it's like 20 days here, but the evaluation is continuing. So the first trial date was kicked back. It was supposed to start now November 18th, but the reports now are saying that the judge has granted the defense's request for an extension to continue this hospitalized evaluation for Brian Walshe. And it seems like the judge has ordered that Brian Walshe is to come back to court November 17th. That's a hearing that's been put on the calendar. That is the final pretrial hearing. So from my perspective, I don't really know how Brian Walshe and his team can do some of, most of the prep or a ton of the prep for a trial happens in this last month. And between October 24th and November 17th is basically a month before trial. So how are they doing all of this work without the input of Brian Walshe? Are they going to bring that to the judge's attention? Are they going to try to continue the case and say, Judge, we blew the last, month and a half with this competency issue. And when he's in the state hospital being evaluated, we were not able to fully prep for trial. We still want proctor documents, or we still have to talk to him and discuss whether or not he's going to testify. We saw how that came up with the Donna Adelson situation where they had multiple conversations. Well, now if they say, Judge, we need more time to talk to him about whether or not he's even going to testify, because look at everything that's happening. So I foresee that as a potential problem. And if he's going to show up at the last pretrial and we don't even know if he's competent or not, this is a very, very common reason that a trial gets continued. So the main point of all this and the main question everybody has is this trial actually going to start on November 18th? My guess as we sit here right now is no. But if you would have asked me before Karen Reed's first trial, when both sides said they weren't ready and both sides wanted a continuance and both sides asked for it, I would have told you, and I think I probably did at the time, the judge is probably going to say yes. The judge always says yes to that. And I was dead wrong. Cannoni said, nope, we're going to trial. Nothing you can do about it. No ifs, ands, or buts about it. So it looks like this case might still be tracking for trial, even though in my experience, when something like this pops up right at the last minute, usually this is a pretty good reason for trial to be delayed. Fab said, can anybody else not hear him? I don't see anybody else saying they're having audio issues. Maybe if you go out and come back in, it might be because, you haven't liked the video yet. That was just a joke. Okay. So the vast majority of you in the chat said you think it is a stall tactic. He is trying to delay this trial. And I would say, I understand why you guys feel that way. And that is absolutely something that's happened in the past where we can say with a lot of confidence, now it's not appropriate to do that if a competency issue doesn't really exist. That's not appropriate for lawyers to try to delay the trial like that or clients, but I would say it probably has happened. There's also no punishment or repercussion on the lawyer if it comes back after the evaluation and they say, nope, he is perfectly fine. He's competent. He can go forward to trial. That happens a lot. You still have to act in an abundance of caution. You don't want to go forward with your client not competent. That's not appropriate. That's not protecting their rights. That's literally what lawyers do. That's what we swear to do. It's a profession of ethics. So we do have to do that. So a lot of people, no surprise, believe that this happened because Brian Walshe was trying to delay this trial. But I think if you look at the timing of this, it seems like they want to go to trial. It seems like they're ready. If they need more time for the proctor information, I think they could probably get it. But Bree brought this up. I thought his competency is at issue because he was attacked in jail. And this is something that is unusual. This is something that doesn't happen in every case. But there were reports that there was a stabbing at the jail and Brian Walshe was the apparent victim of that. And that can be something that's very serious. Obviously, you have a high-profile trial. You have a lot of stuff going on, a lot of stress. We've had clients that, freak out before trial all the time. That's not that unusual, but that's not necessarily meaning that they're not competent. But a traumatic event where you're attacked and injured, to me, is a pretty good reason for the timeline of this case seemed to be leading up to trial. And now we have an issue with Brian Walshe. And I think it's reasonable to believe that it could have something to do with the prison attack. And so that was a good point brought up by Bree. And I think those are probably the two most reasonable explanations for the timing of all of this, is that you are trying to delay the trial or you have an attack that really affects you. Priya said, can you have PTSD and still be found competent? Yes. Yes. You can have mental disorders. You can have mental diseases. You can have mental defects. You can be stressed out. You can have PTSD. You can have all sorts of things and still be competent to stand for trial. And this is just a great question and kind of good context around all this, because where is the line? The line really is, regardless of everything else going on in your life, because you're going to be stressed. You're going to have anxiety before your life is literally on the line and you've been accused of the worst of the worst, if you're maintaining your innocence or not. But you have all of those issues. The one question really that these mental health experts are trying to answer for the court, for the lawyers, for the client is, do they understand what's happening to them? The legal proceedings, the potential penalties against them. Can they make decisions like, will I testify or not? Are they able to help their defense attorney saying, yes, this witness, no, that witness, yes, this piece of evidence, no, that piece of evidence? Obviously, the lawyers make those strategic decisions, but your client, for any lawyer that's ever had a case, and we just, talked to the lawyers in the Karen Reed case, and they talked about how intimately involved Karen Reed was in her own defense, like having another defense lawyer there. So it's very important for the defendant to be involved and understand what's going on. But people are presumed competent. In order to be found incompetent, somebody's got to look at them, a professional, an expert needs to look at them and say, you are not competent. Because if they can't make that call, somebody is presumed competent, which that's what they'll say. This person is competent. They are presumed competent. It has to be like Lori Vallow was kind of a good example, right? We've all kind of seen Lori Vallow's issues present themselves, and she had competency issues throughout her pretrial phase. But Anna said, can you pretend like you're crazy? So mental health experts are trained on dealing with people that malinger or lie or exaggerate or fake. And yeah, a lot of people are saying, oh, you can play crazy. I get it, but that's the point of having a mental health evaluator and not having a lawyer try to figure it out or just the client decide whether they're competent or not. That's the point of having these experts. They are trained on it. They are asked questions like that. When they make those types of determinations, all of that is taken into account. So hopefully that's not what happens in a lot of these cases. Of course, I'm sure it does happen from time to time. I'm sure it happens in insanity defenses, right? Where, a lot of times you have these experts that are interviewing defendants to figure out if they're insane or temporarily insane at the time of the commission of the crime. Sometimes the prosecutors, experts agree with the defense experts, and this person either gets sent to a mental facility or, just obviously is not guilty by reason of insanity. And maybe they fake it sometimes. I'm sure that it has happened, right? I'm sure that it has happened. But generally speaking, their training has to kick in. It's got to be part of the evaluation. And hopefully that's not what things don't slip through the cracks. So Brian Walsh case, still things to be argued about. Will they get any of the Proctor text or Karen Reed federal information? We don't know. Will he be found to be competent or incompetent? We don't know. It looks like all eyes are towards November 17th now. So we have almost a month break in this case before we're probably going to have any major updates. So now let's take a quick break and then we will transition into the Kouri Richins case. Fall is one of my favorite seasons of the year, but it's also by far the busiest season. We've got school, we've got work, we've got travel, we've got holidays, we've got everything. And when things get busy, sometimes sleep can fall to the back seat, and that is a huge mistake. I just went on vacation recently and did not bring Dream with me, and I was miserable not getting the sleep I needed. As soon as I got home, I hit the Dream and slept like a baby, and now I am back on track. Dream has been a great supporter and sponsor of this channel for a long time, and it really works. I fall asleep easier and I stay asleep longer. And because I sleep through the night and I sleep hard through the night, it recharges me for the next day so that I can be uber productive, which is my favorite kind of day. And the best part is you can get early access to Beam's Black Friday sale with up to 50% off for a limited time. So just click my link and use code LYK at checkout. This is Beam's biggest sale of the year and the best deal I've ever shared, so don't miss out. All right, so we're transitioning over into Kouri Richins' case. Netwoman also gifted 10 Lawyer You Know memberships. Thank you, Netwoman. I can already feel it's going to be a good Friday stream, right? I'm happy. I'm energized. I'm excited about the day. The weather's amazing. Like I said, high school football game tonight. It's homecoming at my alma mater. Where my nephew goes, and my kids will probably go in there. Their school feeds into this high school. It's just so much fun. I love it. I'm excited. But I'm also excited we get to come hang out here for an hour first. So, Kouri Richins, we talked about this, I don't know, last week or 2 weeks ago about one of the very important witnesses for the state discussing whether or not they sold Kouri Richins fentanyl or got it for her, the go-between person or the person that provided the fentanyl, flipping their story and saying, actually, it wasn't fentanyl. It was oxy. And guess what? The state has known about this for months and they didn't turn it over to us, judge. Those are the arguments the defense made. And because of that, they said, we need to compel this exculpatory evidence and we want the judge to reconsider bail. Well, last week, the state responded to that. And I think just yesterday, the defense had filed a couple follow-up replies and motions. And those are the ones we're going to look at today. First, last week, the state, they filed their opposition to the defendant's motion to reconsider bail and conditions of release. So the judge has to make a decision here. Why is Kouri Richins denied bail? Why is Kouri Richins being held? Is it because she's a flight risk? Is it because she's a danger to the community? Or is it because the crime charged is very serious and the state has a lot of damning evidence against her and is likely going to convict her? Those are kind of the considerations before this court. He touched on multiple ones as to why she is being held this way. And the defense is saying, judge, if it is because the crime charge is very severe and dangerous, which it is, but because the evidence against her is significant, well, you need to reconsider that factor because something has changed now, a star witness, credibility issues, and they have flipped their testimony. So you'd expect the state to be like, no, judge, we've got no problem. Our evidence is great. Our witness is great. No issues here. Let's hear what they say. The state of Utah requests that this court deny the defendant's motion to reconsider bail and conditions of release because Robert Crozier's recent assertion that he understood, quote unquote, that the pills he sold Carmen Lauber contained only Oxycontin does not amount to a material change in circumstances. Okay. Regardless, substantial evidence exists to support the aggravated M charge, notwithstanding Mr. Crozier's recent assertion. So they're basically agreeing. Judge, we've got a change here, but we do not see this as a material change. And therefore, you should keep the bail as it is. Sally asked about, back Walsh, would that just be for trial or Were they competent at the time of the crime, or both? So that's why I was talking about it. Competent is the time of the trial. Insanity defense would be at the time of the crime. They are not claiming he was insane at the time of the crime, because that's also an affirmative defense, which usually means in the insanity defense is that when you say, I did commit that act, but I was insane, therefore I'm not guilty. And he's not saying that. Jen, thank you for gifting 5 Lawyer memberships. All right, here's the statement of relevant facts per the state. In February of 22, Crozier told Lauber that he could get her fentanyl. And on 2 occasions that month, she purchased from him what she believed to be fentanyl. And they're taking that from Lauber's statement. On May 4th, 23, Summit County detectives interviewed Mr. Crozier. He was certain that he sold fentanyl to Miss Lauber. But you sold Lauber M30s, right? Yeah, I sold her what she knew what she was buying. Detective, it wasn't like she was asking for oxys or something like that and she got M30s. And Crozier said, right, no. So she knew there was fentanyl in those pills. Absolutely. Now, I would argue a lot of that is speculation. How can you know what somebody else knows? You know what she asked for. How do you know what they believe unless they told you? And if they told you, that's hearsay. So issues there, but whatever. Taking that as it is. And this was in May of 23. In September of 25, Crozier recanted his interview with detectives during an interview with defense counsel and asserted that he sold Lauber blues that he got from an unidentified source in early 22. He understood, quote unquote, blues to only contain Oxycontin, and that he did not come to know that blues also referred to fentanyl until late 22. And that's from the updated Crozier affidavit. So here's the state's argument. Mr. Crozier's recent assertion that the pills he sold Lauber contained only Oxycontin does not withstand modest scrutiny. He doesn't know the composition of the pills because, as the defense often notes, they were never tested. So first off, they're saying this as if it's a good fact for them. You guys tell me, who does this usually seem bad for if the evidence wasn't tested and we think it's X, Y, and Z, but if it was never tested, how can you actually prove these things? But the state admits and basically throws it back at them that these drugs were not tested. He was a low-level street dealer who got pills from an unidentified source. What does that make you think? I'll remind everybody of one of my favorite jury instructions that I like to highlight in every closing argument. The credibility of every witness is at issue in this case. You as the jury determine credibility, not the judge, not the lawyers, not the clients. You as the jury determine credibility. Let me remind you of some things that this informant, source, star witness, whatever you want to call him for the state was. Here are all the credibility issues. You are absolutely allowed to, and I would say instructed to by the judge, if you don't find him credible. And I would argue all these reasons he's not very credible. Even the state agrees. He's a low-level street dealer who got the pills from some unidentified source. If you don't find him to be credible, you should throw out all of his testimony. You're absolutely legally allowed to do that, to disregard and throw out all of his testimony. And if you do that, if you throw out his testimony, did the state really prove this case beyond a reasonable doubt? At a time where nearly every pill on the street, back to the motion, by the way, contains some amount of fentanyl. Okay, that's the argument that they're going with. And they're going to have an argument say, they're going to have an expert say that every pill had fentanyl. Mr. Crozier speculates that the pills contained only Oxycontin simply because he did not come to know that blues referred to fentanyl until a few months after he sold the blues to Miss Lauber. Okay? So now they're going to use speculates. But here, he's saying what somebody else knew multiple times. And by the way, I am by no means saying that Mr. Crozier's second statement and updated statement is the truth. I'm not saying that. Sure, the defense is going to argue that, but the number one thing the defense has now is there's something we can agree on with the state. This guy is not credible. So the state did not prove this fact. That's what I would argue. And it shows weakness. Benny Bella said yes, but he was detoxing from fentanyl, which means he had been on fentanyl, which he sold her the little blues. So it's possible he could have sold fentanyl. Yeah, but that's also possible that he wasn't in his right mind back then, and now he is in his right mind. So that's why we should take this statement as more credible than the prior statement, right? That's an argument. And this is opening up arguments the state will absolutely have to deal with at trial that the defense has. Mr. Crozier's recent assertion is further impeached, okay? They're talking about how their own witness is being impeached multiple times, multiple ways, by the May 23 interview in which he denied that he sold Miss Lauder oxys and affirmed that M30s that he sold her contained fentanyl and that she absolutely knew that they contained fentanyl. Ms. Lauber corroborates Mr. Crozier's interview with testimony that she asked Mr. Crozier for fentanyl and believed that she received fentanyl from him. Ultimately, of course, Mr. Crozier's interview is corroborated by the constellation of means, motive, and opportunity evidence against the defendant and the toxicology reports showing that Eric Richins died of fentanyl poisoning. So again, they have some corroborating evidence. They have other statements that I think the defense thinks they can impeach. And they have, of course, the fact that Eric Richins died of fentanyl poisoning. But will this circumstantial evidence be enough for the jury to believe it was, in fact, Kouri Richins? Mr. Crozier's recent assertion does not amount to a material change in circumstances because it's not credible. This makes me want to barf. If one of your material witnesses, there is no doubt, I will just tell you, no argument at all that this guy is not material, recants and completely changes his assertion, even if you don't find it to be credible. For you to say that that is not exculpatory is like blatant misconduct, in my opinion. Because then, what would that stop any prosecutor at any point saying any witness changing their story or having impeachment material or having somebody say that's not what they told me? How in the world would you ever have to turn it over? You would never have to turn that over if it was up to you to determine the credibility and you just said, we didn't think that was credible. I mean, you could go as far as saying there's video evidence of somebody else committing the crime. Well, we think that video evidence isn't real. It's like, no, if it exists, turn it over. Even if you think it's AI or doctored, have an expert say, this was created, this isn't real, fine, but you still have to turn it over. It doesn't mean it's going to come out at trial. So that's an issue. How much fentanyl did he have in his system? I don't know the exact amount. I'm sure we're going to hear from experts say, he had a lot, a little, enough to kill a horse, whatever. We're going to hear evidence of that. I don't know off the top of my head. Young Black economist, late discovery seems like a systemic issue which prosecutors and legislators aren't willing to address. It's a systemic, horrible material issue in criminal cases for prosecutors and in civil cases for big companies. Because they have all these excuses like, all this red tape, it's hard for us. It's like, but we have rules. And Florida has been trying to crack down on it because they've implemented more sanctions and harsher sanctions and stricter sanctions where it used to be judges may sanction somebody for discovery violations or dilatory tactics, meaning delay tactics. And now it says must or shall. And I was all for those changes because it is so frustrating. And you're right. This is not just happening in Norfolk County, right? This is not just happening in Utah or Florida. There's not a lot of repercussion for these types of things. Any type of reform to courts and prisons has always been unpopular amongst their donors. Yeah, why do we think that is? Chrissy said, has Peter ever tried a criminal trial? Yes, I have. I've tried one as an assistant state attorney. I've tried one as a state criminal defense attorney, and I've tried one as a federal criminal defense attorney. I've never been a federal prosecutor, though. Only on the defense side in federal court. Okay. Regardless, it does not detract from the substantial evidence that the court has twice found capable of supporting a jury finding that the defendant is guilty beyond a reasonable doubt. Yeah, the language here I don't love, but this is the point of why she should get no bail. A reasonable jury could choose to completely discredit Crozier's recent assertion for the reasons stated above or assign it de minimis weight in comparison to the weight of the evidence well established in the record that the defendant committed aggravated M. This right here is an admission of the exculpatory nature and the mandatory discovery nature of this statement. If they are willing to say as prosecutors that a reasonable jury could choose to completely discredit Mr. Crozier's recent assertion, that to me is admitting they can also choose to completely discredit his first statement. We know as lawyers, right? I've tried a lot of cases. Sometimes I know exactly what the jury is thinking. Sometimes I don't. We don't always know what the jury is thinking. And that's why the standard often is, could a reasonable jury think something? And you can't tell me with a straight face that a reasonable jury might not just completely throw out Crozier's statement when before they may have believed it. And that is exculpatory. You have to turn that over. That has to be considered. If I was the judge, I would not be happy with how the state handled this motion and this issue and not turning that over. Conclusion, the court should deny the motion because Crozier's recent assertion that he sold pills to Ms. Lauber that contained only Oxycontin lacks sufficient credibility to amount to a material change of circumstances. Regardless, substantial evidence exists to support the aggravated M charge, notwithstanding his recent assertion. I'm not a fan of this filing. I'm not a fan of the way they're looking at how all this went down. All right, next. Now we get the defendant's reply to that motion we just read, to the state's motion, to the state's opposition to the defendant's motion to reconsider bail and conditions of release and request for hearing. And they start with a quote, which again is a bit of an eye roll for me. I've never started a motion ever in my life with a quote. Truth is not what you want it to be. It is what it is. And you must bend to its power or live a lie. Okay, thank you for that. In arguing for Ms. Richins' detention, the state claimed that Carmen Lauber purchased fentanyl from Robert Crozier and provided it to Ms. Richins, who then somehow got her husband to ingest a fatal dose without his knowledge. The state has conceded that these alleged pills have never been located or tested. The state has never claimed that Carmen Lauber tested these pills or had personal knowledge of their chemical makeup. But Crozier said she knew that they were fentanyl. And if Crozier said she knew it, then she must have known it, right? Instead, the state has continuously relied on their argument that Ms. Carmen Lauber's testimony that she purchased fentanyl is reliable in large part because it is corroborated by other witnesses. This claim of corroboration has been pointed to in the state's pleadings, and testimony regarding these corroborating witnesses was elicited by the state from Detective O'Driscoll at the preliminary hearing. The state has relied on only one of the corroborating witnesses, Mr. Robert Crozier, to testify that the pills provided to Carmen Lauber were, in fact, fentanyl. He is the only witness who could potentially claim a direct connection between fentanyl and Ms. Richins. However, now that Mr. Crozier has stated under oath that he did not provide fentanyl to Ms. Lauber, the state is asking this court to find that one of their most important witnesses is no longer credible. So here's what I'm going to say. And I have a question because I've been making an assumption and I don't like to make assumptions. My assumption that I've been making that I want to ask as a poll question, Kelsey, will you put this poll together? Do you think Crozier is a material witness? I'm not going to say, do you think he's credible? I'm not going to ask which story you believe. That's all fine. We're going to wait to see how it all comes out. But do you think he's important? Do you think Crozier is a material witness? Yes or no? So Kelsey, will you put that up? Texting her just to make sure she's watching here to throw that up. Okay, so she said yes. So that poll should be going up now. And we'll read the results. I see a lot of you guys saying in the chat. Here's something I want to say. So vote in the poll so we can get the full percentage, but tell me why in the chat. Why did you vote the way that you voted? And we'll keep reading. Although ultimately Mr. Crozier's credibility will be determined by a jury, at this stage, it is the province of the court to listen to Mr. Crozier and make that determination. And this is for the bail decision, right? The court's not going to determine credibility for guilt or innocence at this point. This is for bail. Notably, it has never been the job of the prosecutor to determine the credibility of a witness, not for purposes of bail, nor any other purpose. Should this court find Mr. Crozier's testimony to be credible, the weight of the evidence in this case will be significantly changed from that which existed at the time of the last detention hearing in this matter. The elimination of the state's alleged link of fentanyl to the defendant is a material change in circumstances, and without it, the state can no longer claim the existence of substantial evidence sufficient to support a denial of bail. Here's what I'll say. Number one, I agree with the defense that the elimination of the state's alleged link is a material change of circumstances. I agree with them. I think that is a material change of circumstances. But I don't think they're correct to say the state can no longer claim existence of substantial evidence. I think the state can absolutely still claim substantial evidence sufficient to support denial of bail. And if the judge agreed to keep bail in place, I wouldn't necessarily have an issue with it. So while I'm banging the table here and we're talking about the issues in this case, I think they're going to be a major issue of credibility at trial that could be a black mark for the state that they're going to have to try to get over with this jury that the defense is going to be able to really hone in on and highlight. I don't think that it's over. I don't think it's a house of cards that has come tumbling down. Shelley said he's a material witness, but is only one piece of the puzzle. I agree with that. I completely agree with that. One piece to the puzzle. I think the state has a lot of different angles they can take on this. The purpose of the substantial evidence standard is to ensure that the quantum of evidence presented by the state sufficiently justifies the denial of the defendant's right to freedom from pretrial incarceration. Now, the defense is kind of ignoring how serious the crimes are, dangerous the crimes are, whether the judge thinks she's a danger to the community, which can be kind of a combination as to why he might deny bail. Because the state is now placing Mr. Crozier's credibility into question, the defense is requesting an in-person hearing to enable this court to observe Mr. Crozier's testimony and demeanor and to decide whether Mr. Crozier's credibility is sufficient to support Ms. Richins' claims that there's no longer substantial evidence to support a jury verdict of guilt. I agree with them here. So as you can tell, it's like some things I agree with the defense, some things I don't. I think there's enough here for the judge to have a hearing. And I also think if the judge did have a hearing, it would be the same result. Such a finding would require the setting of bail as a matter of law. Okay, that's their argument. For the reasons stated herein, and in Ms. Richins' motion to reconsider bail, the defendant respectfully requests that the court schedule a detention hearing as soon as practicable and release Ms. Richins on a combination of bail and conditions. Okay, so I would agree with them that I think the court should set a hearing. I don't necessarily know what the court is going to do. All right, last motion we're going to read here together. This is the reply to the state's opposition to the defendant's request for order compelling disclosure of exculpatory evidence. In its request for order compelling disclosure of exculpatory evidence, defense counsel moved this court for a standing order. We read this together, imposing a 3-day deadline on the prosecution to disclose the following to the defense. All evidence, including emails, text messages, phone messages, recordings, video footage, or any other form of correspondence involving the prosecution teams or any law enforcement official and Robert Crozier, including the correspondence about setting up a meeting and any sort of summaries of the meeting. All notes, correspondence, or reports prepared by law enforcement officials or any member of the prosecution team discussing Robert Crozier's interview in April and or any other dates. To me, that seems pretty stinking reasonable. That seems very, very reasonable. Any statements, recordings, reports, or notes in whatever medium, including emails and text, that tend to negate guilt. Yeah, duh. You really shouldn't have to ask for those types of materials. That should be obvious. That should be automatic. You shouldn't even think about that if you are the state. In its opposition, the prosecutor stated that defense requests should be denied because there is no undisclosed exculpatory evidence. So once again, we have a prosecutor saying, nothing to see here, Judge. We didn't have to turn this over. It's not exculpatory. His recanting of his prior statements, we don't find that to be credible. So glad we have them to do that for us. It submitted 2 affidavits in support of their opposition. The state did not deny that they did not provide Mr. Crozier's statement that he never sold fentanyl. So according to the defense, the state is agreeing that they never turned this over. To me, that's a major violation. That's sanctionable in my opinion. You guys know I don't like to say lawyers should be sanctioned. That you cannot be doing stuff like that because, again, as the defense, who knows what other witnesses may have recanted. But if the state doesn't find it credible, the defense may never find out. And again, I'm not saying that the jury's going to buy this. I'm not even saying that this has to come in at trial at this point. I think it should, but they definitely have to turn it over. It is a very low bar for what needs to be discovered in these situations. Only OxyContin to Carmen Lauber, but rather determined that it was not exculpatory. So the state didn't turn it over because they said it was not exculpatory. This was not the state's determination to make. Ding, ding, ding. Clearly, Mr. Crozier's statement recanting that he sold fentanyl is more than potentially exculpatory, yet it was not provided to the defense. Therefore, the state should be required to turn over all statements made by witnesses as stated above, so the defense has all potentially exculpatory evidence prior to trial. Further, the prosecution did not articulate an objection to defense's standing order request. With no objection to the standing order, the defense requests the court grant the motion for a standing order. Yeah, if they don't object, then bada bing, bada bang, the standing order should be in place. Okay, the poll results here that Kelsey sent in are about 60% of people believe. I think this was a couple minutes ago, so if you have an updated one, Kelsey, feel free to send it. 60% of people in the chat believe that Crozier is a material witness. 40% think he is not. That is a much closer split than I was expecting. I thought it would be much higher. So as we sit here, I'm glad I asked because I was making assumptions, and you know what they say about assumptions. If Crozier is telling the truth, then Carmen is lying. She couldn't have the drugs from him. You know what, Nina, you make a great point. I don't know if Carmen was lying or not, but do you know what this does do? This allows the defense to also not just crush Crozier's credibility, but crush Carmen's credibility. And if they can crush those two witnesses' credibility, at least in combination, I think most people would find those two witnesses to be material. So if they could crush not one, but two witnesses' credibility, that's not exculpatory? Come on. That's just bad form, in my opinion. Shouldn't be. We can't have prosecutors doing things like that. We really can't. All right. So everybody hit that like button. That's the end of Walshe and Kouri Richins, but we're going to do an AMA Ask Me Anything Q&A here for the last 10, 15 minutes of the show for whoever wants to hang around for that. It can be on either of these cases. It can literally be anything, and we can run through as many questions as we can. I'll try to do rapid fire. I'll add context as much to the ones that we need to. But first, Netwoman with a banger of a super chat here. Starting the weekend off right. Let's get an answer for her. Off topic / on topic, my favorite. Skaggs v. Angels civil trial, no stream. California sucks. That's Netwoman saying that, not me, of course. Supposed to be 1 week trial in September. Took 1 week to get a jury. 12 jurors with 6 alternates. Skaggs family suit over communications director supplying drugs to players and Angels should have known Skaggs died in a hotel on his way to the game. Angels say Skaggs' death own fault for alcohol and drug. Part 1. Let me scroll and see if I can find part 2. Kelsey, can you try to find part 2 of her question? I'm going to scroll back up to this and see if I can find part 2 to this. All right. I'm not seeing part 2. But Skaggs was a Major League Baseball player for the Angels. I didn't even know this trial was starting. Kelsey said she's been looking for part 2 too and doesn't see it. All right. I will wait for part 2. But 12 jurors, 6 alternates. That's a pretty big jury for a 1-week trial. And it taking a week to pick a jury, I will tell you that that's not that surprising in the fact that you're dealing with a sports star-ish in town and the hometown team. So from my perspective, taking that long to pick a jury, not that surprising. Not that surprising. All right, we'll see if question number 2 comes. Sparking Rudabaga said, did anything happen to the drug dealer? Did he get immunity or something? I don't know. I think there was some kind of deal to be worked out, but I don't know. I don't know the specifics of what happened there. Nina, should Kouri get bail in your opinion? So I will tell you with this case, I don't know every single little detail and piece of evidence they have against her. I trust this judge's this judge has seemed really fair to me throughout the entire process. I don't necessarily trust the state to be fair anymore after some of these filings. I would trust the judge's decision on this. If it were me, I would probably say no. Based on some of the shenanigans that's happened from jail, some of the accusations made by the victim's family, and the evidence they have against her in combination with how she was acting while she was out. But she didn't flee. A lot of stuff happened in, the year that she was out after the death, but before she was charged. My decision based on what I know would probably be no bail. Susie Hatt said, super important question. Are you letting your hair grow out, Peter? So no, it's probably getting close for a time for a cut. I actually looked at a picture of a case that I tried. Was it 2 years ago? And my hair was crazy long. It was like, had a mind of its own. My beard was long. I looked unruly, but it went really well that trial. So maybe I should bring it back. Chris, Peter, in pickleball, what would be your next hit after the return when you're the serving team? I need to move up my pickleball league. I usually go with a third shot drop. If it's a really high ball, I'll do a third shot drive, which then will make the drop easier. But my favorite part and my most advanced skill and my biggest advantage is at the net. So I'm doing everything I can to get up to the kitchen line and be at the net. And usually that's a third shot drop. Valo Queen, thank you so much for gifting a Lawyer You Know membership. JM Willow for the Q&A. Do you have pets? I do not. I do not. Allie, thanks for being you and not being mean to people with opposing opinions. What's the fun in that? Why would I want to come here and just have everybody agree with me, right? How boring is that? Maybe it's how I was brought up in my family. We all disagree with each other. Same thing with my kids. And, my wife, we'll get into it. My wife is pretty much a peacemaker and chill. But, that's just fun. I feel like that's how you learn. I want my kids to ask questions. If they do agree with me, okay. Whitney sent me what she believes to be part two. But let me finish answering this question. I love differing opinions. Always have, always will. And that's what this will be. Always. This will be a place where we can discuss our differences and what we think differently. Okay. Second part of the question. The trial stopped because the Angels said that K was wrongfully convicted. Family suing for $214 million. Thoughts? Gosh, I wish I knew more about this. I wish I knew more about this so that I could give you a better answer. I don't know. But I could understand how if they think somebody's wrongfully convicted and they want to go try to get that evidence out, how it's important because if somebody was already convicted, that's going to be res judicata, and that's going to be something that's allowed to be used in the civil trial. The Abby Zwerner civil trial begins October 27th. Will you be covering it? I don't know anything about that. This is the case where the 6-year-old asked his teacher during class after warnings the school the child had a G. Oh. Listen, here's how we pick our trials. Everybody listening to this, if you're interested in this, let me know. get in the chat, get in the comments, send me DMs on Twitter. And if enough people are interested in it, absolutely. Are there any updates with the NBA craziness? I'm just ending my week and jumping in. John, I have read a ton of crazy updates. Let me just tell you, this is rank speculation at this point. This is Twitter. This is tabloids. This is headlines. But this case is spinning out of control at this point. By the way, somebody asked me from I think it's a local Boston sports radio show to come on this weekend. I'm going to try to. I don't know that I can. I don't know if I'll be able to or not. But I have read articles saying Kevin Garnett was also used in it. I've read articles saying that they used Kylie Jenner's house while she still owned it to do these poker tournaments. I have seen clips come up from 2 years ago saying, oh, look, this poker guy said he was invited to go play with Chauncey Billups, and I knew it was rigged. Everybody that goes there knew it was rigged, so I didn't go. And afterwards, everybody reported to me that it was rigged. Gilbert Arenas tweets that, like, he's snitching on people. It is wild, the stuff that's happening right now and all the different ways it can go. And it seems like some of the bigger accounts are saying this is just the beginning. I don't know if you guys know who Pablo Torre is, but I think people mentioned him. Was it the Mark Sanchez story that he broke? But he's breaking all sorts of stories, and he's, digging into stuff. And apparently he's got his hands on this one as well. So we will see. Do you do live, cut, or fake Christmas trees? So cut, meaning do I go cut it down myself? Definitely not that option. This is always like a certain kind of subject in my house because my wife has, I don't know how many Christmas trees we have at this point. I literally think it's over 10. I think we have more than 10 Christmas trees in our house. We have a fake tree that we put like all the kids' ornaments that they've built and that we put our presents under. We always go get a live tree though every single year. I think the day after Thanksgiving, my wife starts decorating for Christmas on November 1st. Just everybody who wants to talk about how they feel about that in the chat. We do a live Christmas tree every year and like the entryway to our house with our winding staircase. And it's really fun to decorate. My wife decorates that one by herself and it looks beautiful and I absolutely love it. But yes, we have 1 million Christmas trees, one live one, the rest are fake. But we don't like cut it ourselves. We go to either a Christmas tree farm or store or whatever and buy it. Is there a trial you wish you could have covered, but it was too late, conflicted? I would have loved to cover the O.J. Simpson trial. That's probably number one on my list. Wild lawyering, wild outcome. Recently saw a sentencing and they swore them in, plus allowed both sides to question them. Is that standard? In a lot of sentencing, yes, that is standard and that is allowed and normal. I need some lawyer merch that says "See you in court" with a pickleball paddle incorporated to wear to my pickleball league. Well, you're in luck because we happen to be designing a bunch of new merch right now. So Kelsey, take a note of this. I would love that as well. I want to get that myself. I'll get some samples of my own merch that say "See you in court" with the lawyer logo on it and some pickleball flair to it. Yay for your wife. Love Christmas too. Christmas is by far our entire household's favorite holiday as a whole. What would you consider to be a fair sanction for the prosecution? Maybe offering the defense. Would they want to strike this witness altogether? Would they want to strike Crozier altogether? That might be number one. Number two might be you can no longer determine if things are exculpatory or not. You have to have a supervisor sign off on any decision you make to not turn over something in discovery. Like maybe have them be babysat. A public reprimand telling them that you can't do this. Maybe adding them to a Brady list. Seriously, because I just would never want to go up against a prosecutor like this that would just, they're making decisions arbitrarily about credibility of witnesses and therefore a recanting of a prior statement that you plan on using at trial is not exculpatory? What? Come on. What are the top 2 to 3 things you learned from your parents? Oh, that's impossible. This is an impossible question. Love your neighbor as yourself. Don't be selfish. Treat other people like Jesus. Do everything you do to the best of your ability. What are some other ones? I don't know. Don't lie, cheat, steal. What you do in private is more apparent of your character than what you do in public. Matters more. Some content creators aren't as nice at, if you disagree, sometimes get called a troll for it. I mean, I think there are people that say personal, stupid, jerky, horrible stuff, and it's just not necessary. and I don't want to respond to that, like the ad hominem attacks I'm not interested in, but like well thought out things that completely disagree with me or tell me I'm wrong, I'm down for that. OJ as defense or prosecution, I probably would have rather prosecuted the case, honestly. I think it would have been a fun prosecution. I would have done it very differently than they did. My Christmas Village starts November 1st too. It takes out a couple weeks to put everything out. Yeah, my wife's become a big fan of the Christmas Village, the houses and stuff. And I love the way it looks. It's really fun. Is there a trial where you thought the jury really got it wrong? Parkland shooter sentencing trial. I thought he deserved the death penalty myself personally. That would have been my vote based on what I saw and heard. It's the first one that popped into my head. Where could you cut down a Christmas tree in Florida? Yeah, I just wanted to answer the question appropriately. Okay. I really just wanted to answer the question appropriately. Jen was literally typing to ask when Whitney is going to start decorating for Christmas. I start on 11/1/2. Just got my merch order this week and love it all. Hope the Tragos fam and everyone in Lure land has a fabulous weekend. Thank you so much, Jen. Yeah, so we're doing some fun things behind the scenes, and it's going to be fun. We're going to talk about it more in the Members Only Live. And as the new merch designs come out, we're going to give away a bunch of it in the Members Only Live. And then Black Friday is always our biggest sale of the year at the merch store, which is always fun. So we're going to do a big sale in the merch store. And new stuff coming out, fresh stuff, fun stuff. We already have Christmas stuff from last year that's still in the merch store. If anybody wants to order that, obviously you can, but, that's some stuff coming up here for the end of the year. I absolutely love the end of the year. We had a big trial that was supposed to go in December. I think I'm waiting on a text message from co-counsel and opposing counsel that we are supposed to settle that case, which would mean kind of smooth sailing for the end of the year. We'll see if any of the trials we're covering goes, because it's been kind of slow trial coverage wise as well. I did look into that Julio Fulio trial a little bit. Seemed interesting, but didn't seem like a lot of people had questions about it. Jen said, do you send merch overseas? Yes. I think the answer to that is yes. John is not on the stream, but I'm 99% sure the answer is yes. I think sometimes it does take a little bit longer. I'm 100% sure the answer is yes, but sometimes it does take longer. Favorite holiday dinner dish? I love turkey on Thanksgiving. I know I don't eat a lot of it, but I love turkey, mashed potatoes, Greek salad that my mom makes. Like, those are my favorite kind of things, just kind of like the staples. I'm not a big cranberry guy. I don't like stuffing. I don't like biscuits and gravy and stuff like that. Christmas, we do filet. Like, we do that at my house. I grill it. Family comes over, filet, steak. We do some chicken and stuff as well, but I love that. And we do Greek potatoes and Greek salad. That's my favorite meal probably right now. We never hear about your mom. How is she? I talk about her a lot, maybe more in the Members Only Live, but obviously my dad comes on a lot. He's a lawyer. We're talking legal topics. I am more, here's a surprise for some people, I am way more personality type like my mom than my dad. That usually shocks people. He's more chill, laid back, not bothered. He has some type A in him too, but me and my mom, type A, OCD, crazy about stuff. Much more like my mom, But she doesn't have she doesn't like public speaking. She doesn't like doing stuff like that. That my dad obviously does, but I'm a mix, I would say. But if I had to pick who I'm more like, I would definitely say my mom than my dad. And me and my mom have a really awesome relationship. I would say most of my life, me and my mom were closer than me and my dad. My dad being a lawyer when I was in law school, my dad and I got a lot closer. And then obviously working with him and stuff. Love working with him. Love doing the podcast with him. I have a great relationship with both of them, and absolutely love the relationship I had with both of them. Would love some lawyer, to do some Julio Fulio trial episodes. I don't like to get so behind that it's hard to catch up, and then I don't know all the details and things like that. So we'll see if people have a lot of questions about it. What are Greek potatoes? I would describe them as like olive oil, lemon, oregano potatoes, cut up and, cooked for a long time. And they're like the perfect texture. It's like, it's amazing. He's definitely not silent. Definitely not silent. Are you going to break down the Karen Reed answer? I already did, Tessa. I think it's 2 videos ago, maybe 2 videos ago. So celebrate that I already did the video. All right. That's all we got. I love you guys so much. 1-hour video. Love when a plan comes together. Please hit that like button. Make sure you are subscribed as well, because I can't tell you how many people have been like, oh, YouTube unsubscribe me. So make sure you're subscribed. Tell your friends to subscribe. We're still pushing slowly towards 600,000 subscribers. But I love you guys for coming to hang out with me as always. This was so fun. If anybody's going to be at the Calvert football game, come up and say hi. I had some people stop by my office from Massachusetts to say hi this week, which that was always fun, and took a picture. But until the next one, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, X, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast featuring new episodes every week. And if you have a case that you want to personally talk to us about in your life, if it's a personal injury case, wrongful death, catastrophic injury, car accident, truck accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.